Hi everyone, welcome to the next instalment in Jones Chase's A to Z of Employment Law. This short video is on the letter Q for questions asked in interviews. I hope this video can serve as useful guidance for those preparing and asking interview questions during a recruitment process. Now, an interview is a fundamental and often decisive stage of a selection process. However, it is also the stage where it is easiest to make judgments about a candidate based on instant, subjective, and often irrelevant impressions. Therefore, it is fundamental that the questions asked in an interview do not discriminate. If assumptions about the capabilities of people from a particular group sharing a protected characteristic contribute to an unfavourable impression or unconscious bias, this could lead to an unlawful recruitment process. As we know, the Equality Act 2010 protects individuals in the UK from discrimination, harassment and victimisation. In employment law, we often find these protections covered in employee handbooks and policies to ensure that everyone is being treated fairly and equally at work. However, it is pertinent to remember that the Equality Act applies not only to employees and workers, but to applicants and potential applicants as well. Under the Equality Act, it is against the law to discriminate against anyone because of a protected characteristic. As a quick reminder, the protected characteristics currently listed in the Equality Act are age, disability, which includes asking about someone's health, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. Whilst it might seem obvious to not directly ask an applicant about any of these protected characteristics, it is important to carefully consider the questions that are being asked, the reason why each question is being asked, the relevance of each question to the role, and the inferences that might be drawn from each question. In relation to the protected characteristic of age, for example, an inappropriate question might be asking an applicant about how long they see themselves working until they retire. Ultimately, if an applicant is asked questions that relate to a protected characteristic under the Equality Act and are then treated less favourably because of their answer, they may have a claim for unlawful discrimination. For example, in the case of Chorus Hotels and Woodward, the employer was ordered to pay £4,000 for injury to feelings to a prospective female employee on the basis of interview questions which implied that she would not be able to hold down the job because she was a single mother. There are some circumstances where you might be able to ask questions about protected characteristics during recruitment. These circumstances are limited to being for equality and diversity monitoring, to make reasonable adjustments, to use positive action during recruitment, if there's a disability exception, or if there's an occupational requirement. Now, another area to be conscious about in the interview process is questioning prospective employees on previous criminal convictions. The Rehabilitation of Offenders Act allows most convictions and all cautions, reprimands and final warnings to be spent after a certain period of time. This act gives people with spent convictions, cautions, reprimands and final warnings the legal right to not disclose them when applying for jobs. However, there are some roles that are exempt from the Rehabilitation of Offenders Act, and if the job is exempt, a prospective employer is entitled to request details of any spent and unspent convictions and cautions that are not protected, and is entitled to take this information into account when determining an applicant's suitability for the role. On a practical note, there is some helpful guidance on the ACAS website relating to the recruitment process and the conduct of interviewers. It is a good idea to prepare a set of questions to ask interviewees in advance. Where possible, each applicant should be asked the same question, as this helps to ensure that applicants are treated the same way and a fair recruitment process is carried out. The Equality and Human Rights Commission Code suggests that by preparing interview questions strictly on the basis of any application form, job description, person specification, and by agreeing weight to be given to each criterion in advance and the results of any selection tests, an employer will ensure that all applicants are assessed objectively and solely on the ability to do the job satisfactorily. Interviewers should avoid questions that are not relevant to the requirements of the job, apply a scoring method objectively, and recognise when they are making stereotyped assumptions about people. It is also a good idea to ensure that interviewers understand the law on discrimination. Finally, the ACAS guidance states that if possible, each interview should be carried out by more than one person to reduce the risk of discrimination. This video contains general guidance and points to consider when preparing interview questions. This is not intended to be legal advice. If you would like assistance with any employment law matter, please do not hesitate to get in touch with the team.